Good afternoon and welcome to all of you. For those I don't know, I'm Trevor Morrison. I'm the Dean of the Law School here, and it is my great honor to welcome all of you here today to celebrate the establishment and the launch of the Guarini Institute for Global Legal Studies here at NYU Law School. We are tremendously grateful and honored to be able to welcome Justices Sonia Sotomayor and Albie Sachs, and to thank them for joining us in a conversation today, which will mark the launch of this center. And we want also, of course, to honor our dear, dear friend, longtime supporter and distinguished graduate of this law school, Congressman Frank Guarini. Thank you, Frank, for all that you've done for us. Congressman, we are very grateful that you could be with us here today and that you have so many of your family and friends with you as well. This is a very important day for the law school. Our international and global legal programs are a key part of what have made us a true leader in legal education in this country and indeed around the world. John Sexton is here with us today, a key architect of much of that. And John, we think of ourselves as continuing what you built with this gift from Frank and with the establishment of the Guarini Institute. Ricky Revesz, too, John's successor and my predecessor, continued to build on this. So it leaves a very large set of shoes for me to fill, but sets that I'm eager and grateful to be able to fill as well, to work with all of you in continuing the law school's excellence in training people to be leaders, global leaders, in the practice of law and in the resolution of problems through the law. And none of this, of course, would be possible without Frank Guarini. Frank is among our most cherished friends. He's a visionary, an architect, and a leader internationally himself. Through his career and his philanthropy, he provides a continuing model for all of us in the NYU law community to emulate and to live up to. He has brilliantly shaped and planned this new institute together with us, and we are simply thrilled to be able to celebrate its launch today. Frank, thank you again for your steadfast dedication to our students and faculty and broader law school community and our mission of public service. Now, without further ado, it's my pleasure to introduce Benedict Kingsbury, our Vice Dean for Global Initiatives and the director, the inaugural director of the Guarini Institute for Global Legal Studies. Benedict.
Well, welcome everybody. We gather to celebrate this wonderfully expansive vision and gift from Frank Guarini, which is going to put what's been really a great law school, really a world-leading law school in the international and global field, up to a new level. And the way the world is moving, it seems people have got to be trying to reach those kind of levels. And Frank's really, I think, going to make this possible for us. We feel collectively a big weight of responsibility to try to produce both the rigor and the vision and the expansive forward thinking that Frank himself embodies and has put into this institute even in its early planning. And as from about 2:30 this afternoon, when our distinguished guest, together with Frank, cut that ribbon, 22 Washington Square North, we are going to be starting. So the Guarini Institute for Global Legal Studies invites up the question, what do we think about when we think of global law here? And I think one way to begin that thinking is that it's the connections, the interactions, but also the differentiations, sometimes even the sharp contrasts and conflicts, which go amongst two things, spaces and places. And I think often when we think global, we think rather ethereally of, importantly, but of outer space, of which we have some students working on, of the deep oceans. We have a whole bunch of our students and graduates now up at the United Nations working on protecting biodiversity in those areas beyond any country's national jurisdiction, tremendously important issues for the future. We think of cyberspace, and one of the elements of this new Guarini Institute is going to be a big focus on the possibilities of our students being involved, our faculty thinking through the issues which are posed by the digital world, by the global digital economy, by the global digital companies, and based in Silicon Valley, but increasingly based right here, or big operations right here in New York City, right here in Manhattan, or the startups in Brooklyn. The way in which they are shaping our world, and the way in which the world has to think how it wants to influence that shaping. So we think of those kind of spaces. But I think it's also really central to being a good global lawyer to focus on places. That is, we all have to be rooted somewhere. Rooted in a society, a set of societies that we understand, that we're committed to, rooted in a legal system and robust legal training, which makes us really good lawyers. And to the global part adds the ability to think around corners, to turn the prism, to see problems which are beyond a single state and harder. And it's that combination, I think, of seeing spaces and places together, which really characterizes the whole NYU global enterprise, and I think it's really embodied in what Frank Guarini has been willing to support so generously, what he's seen already the school doing. So when we think of places, we think of New York City, the Village, this law school, even this building where Frank started, really, roughly at the time of this building, which we all live in, enjoy, celebrate, and he's now moving us to a new stage in that, and that kind of localized commitment. But it's local also, and our students are going to be very engaged locally, which they are, things right around us, but also getting to know other places. And we have this wonderful law reward program which sends our JD students who want to, more than 10% of the class now, to Shanghai, to Buenos Aires, to Paris, to become seriously immersed in law, politics, life, ways of thinking there, and understanding the interactions between two or more places. So that's the enterprise, and the ways of trying to address it, we hope, in the NYU spirit, involve a commitment to justice, to the kind of needs and the possibilities that law can bring when law is really done well. And we really aim in our whole enterprise to keep that elevated part of what we're producing for the world, our own research and scholarship and thinking, and in the way we send our students prepared to engage with the world in all the different facets. So we celebrate Frank Guarini as a person who's exactly lived that life in private practice and public service, as a creator of people's spaces, and as a philanthropist and visionary. And it's marvelous for us to have today two of the world's great jurists who embody exactly that set of qualities that this whole enterprise stands for here. So Justice Sotomayor, Justice Sachs, between them have each fought very local struggles, had to do a lot to get to where they are, carried a lot of people with them, inspired enormous numbers of people, not only in their space, but all over the world with what they've done. And I think they bring that wonderful combination of serious lawyering, locally spaced, locally trained, fully equipped to be a good lawyer, but with an expansive, capacious world vision and a capacity to see how change can be done and change properly. So I think this dialogue we're about to launch will exactly be the epitome of what we believe the Guarini Institute and NYU Law School is all about. And with that, I hand it over to them. Thank you.
I am so pleased to be here with you. We're going to close this and make it believe it's a parlor, that we're sitting in your beautiful home in South Africa. In meeting with you, I was thinking about something that my friend Ruth Bader Ginsburg said a number of years back. She was in Egypt speaking to some students and legal scholars, and one of them asked her what they could learn from the American Constitution in shaping their own legal system and government. And she said, characteristically for Ruth, very demurely, well, I don't know how much you can learn from an old Constitution. I think you might be better served looking at something more recent and that took great thought and vision about the world and our ever-changing society by conferring with the South African Constitution. And it splashed all over the US. It didn't meet with uniform approval. But it is true, your Constitution is very different than ours. Ours is not only steeped in precedent, but very parochial in many ways. I mean, I think I admire greatly the South African approach to interpretation, which is charged with looking at how the world deals with the problems that come before it. And as you know, that's not the way we approach judicial interpretation here. But I was also thinking about that question of precedent. I don't know, have you had enough history so that your court has expressed doubts about following precedent? And if you haven't had that history, in 200 years, if your Constitution is still alive, will your successors be well served in trying to think how their founding fathers would have solved the problem? Or do you think that a different approach, the originalists versus the others in the American system, what do you think would happen?
Okay. You throw me into total confusion.
Sorry.
It's tough enough dealing with what's going on now, and you want me to speculate into the future?
I want you to give them some guidance.
Sure. And you're dealing with me. I am an originalist, not an originalist judge. I was one of the people writing the Constitution.
I know.
I sometimes think we should say, we should have like a dance. We are the originalists. And what's so fascinating is we don't even remember exactly what we meant at the time. Because there were so many people, and you had a draft, and it was amended, was changed. I can recall a couple of phrases I can put my little flag on. No detention without trial. That's in our freedom. Very, very specific. That we want an open and democratic society. Not democratic, open, the word open. I insisted on that. For the rest, I was involved in the Bill of Rights, in fundamental rights, in the structures of everything. But I don't think anyone can say this is what we actually meant, because there wasn't an intention in that sense. There was an intention to create a constitution that would serve the nation in future. There wasn't an intention that it would have a fixed meaning that would go into the future. To the extent that we followed American experience, in the recent years, it was an experience to be avoided rather than followed. To the idea of our Constitution was a product of enormous investment, dialogue. The idea that it was a frozen monument to a moment in time would have been completely incredible to us. We didn't even argue that case. It was ending the pain, the offensiveness, the segregation, the diminution of human beings. It was asserting dignity. It was affirming everybody in our country. It was proving to the world it is possible for black and white to live together as equals, that racism is not something inherent in the human condition. We had to do that, otherwise we couldn't get a country. So these were our grand aims. And of course, you need a government, you need accountability, you need elections, you need rights, you need judiciary, but they were instruments towards achieving that end. The end wasn't to create structures of government. The end was to free our people, to open our imaginations, to create a society where even if our living circumstances were grossly unequal because of these ravages of the past, at least in terms of our identity of being a person, being a citizen, we could claim, yes, I'm equal. And we all remember somebody being brought for our first elections, black and white, voting together in one country peacefully. He was brought to the polling station in a wheelbarrow. He was 92 years old, he couldn't walk, and he said, before I die, I want to vote. So for us, the vote was our revolution. You had a revolution. It's amazing, actually, when I speak to Americans, I say you, but everyone I'm speaking to is a child of immigrants who came hundreds of years after the revolution. In any event, America had a revolution, then you got a constitution, then you added a Bill of Rights. We did it all in one. The Constitution is central to that whole project. Getting the Constitution was our revolution. And it was a revolution then that ended apartheid, officialized racism, but had to go beyond that. And I think this was something that Ruth picked up on and that's so relevant to countries, developing countries today. It's not just freedom, the vote, accountable government, fundamental though they are. It's human dignity, including the right to food, to water, to education, to housing, to health, as fundamental rights, and they are in our Constitution. The theme of sexism. Imagine South Africa, the most, not only the most racist country in the world, probably the most patriarchal country in the world. And maybe because of that, a fundamental principle is foundational value, non-racial, non-sexist society. I think Ruth wouldn't have been unhappy
Oh, not at all.
with that phrase there. When it comes to even the definition of freedom, freedom isn't just freedom from arbitrary constraint by the state. It includes freedom from violence, from public or private sources. We had a strong women's group inside our parliament insisting that should be there. I'm sure Ruth wouldn't have minded that being there as well. We have freedom under the Freedom Clause, not a women's rights clause, not a health clause, freedom to make choices about reproductive health. It's in the Constitution. So it's a Constitution then that speaks to our times, but in the language of constitutionalism, and a language that had to take on new colors, new perfumes, if you like, new repellents, if you like, to make it appropriate, adequate, adequado, we say in the language that you speak, for our times. And that's, I think, what made it attractive. Now, when it comes to precedent, just imagine now, we're 11 judges on our court from the most diverse backgrounds imaginable. Arthur Chaskelson had been the most desired, most wanted advocate barrister in Johannesburg. Brilliant young man. Everybody wanted him to handle their cases. He'd appeared in the famous trial of Rivonia trial for Mandela. The commercial groups wanted him. He gave up legal practice to set up a legal resources center, looking to the future. And it wasn't only a new way of legal thinking, it was a new meaning to being a lawyer. You're not this individual trying to build up a practice and a career and get a name for yourself and become famous and rich and wealthy and even be a great leader of the poor. You are part of a team fighting for justice, not thinking about billing your hours, but what can I use, how can I contribute my legal skills and knowledge for the emancipation of my people and for my emancipation so that I can live in a free country. That's Arthur Chaskelson. The way I put it in the case of Arthur was many people have to struggle to overcome disadvantage. He had to struggle to overcome advantage. Where you're born into privilege, it comes with your white skin. And he struggled and he did so beautifully and elegantly. He became our chief. Ismail Muhammad, the first time I appeared in our highest court in the land, then called the Appellate Division of the Supreme Court. I was so thrilled, I was so excited. I'd driven all the way up from Cape Town. It was a murder case, it was technical points on the law of evidence. I held my ground, the Chief Justice was hammering me. I'm taken to lunch by the attorney, and you always want to suck up to your attorneys. And the Chief Justice walks past and he says, "Well done, Advocate Sachs. It's a lawyer's dream." And then the lawyer tells me afterwards, last week, a very brilliant young advocate from Johannesburg came down. He's Indian origin. He had the judges eating out of his hands. When it came to tea time, remember you were given tea, there was no tea for him. When it came to lunchtime, he had to go down to his motor car and eat sandwiches. I couldn't invite him to this club. And of course, I just crashed. He became the Chief Justice of South Africa afterwards, Ismail Mohammed.
Oh.
Varied backgrounds in that way. I'd been in prison, in resistance, blown up. Others had been judges. Richard Goldstone had been a judge, a very distinguished judge, using what space he had on the court under apartheid to try and soften the impact of apartheid. Laurie Ackerman from Afrikaans family, Johan Kriegler from that background, his father had been a diplomat, hated apartheid. And I'm mentioning this to show diverse backgrounds. Yvonne Magaro, grown up extremely poor, and getting scholarships and being a prosecutor, became a professor, teaching at one of the black universities, and becoming the person on our court who introduced the theme of Ubuntu. That's so central to our reasoning and thinking. In our first case was on capital punishment, 400 people on death row, and their lives now depended on us. Is it compatible with our new constitutional order that did not expressly outlaw capital punishment, but it didn't authorize it subject to conditions? And she said, we live in South Africa through the terms of Ubuntu, very deep in African culture. We are humanly interdependent with each other. Sometimes law school erases culture from people, erases humanity and sentiment. It's seen as somehow a negative thing. Rationality is detached from lived experience. And Yvonne comes in with somebody having grown up in a rural area, mother tongue African language, swearing the oath in her Tswana, her language, and speaking in that deeply humane way, Ubuntu fitting in with our Bill of Rights and human dignity and enriching the text of our Constitution. I just give you this as a slice of who we were. Then we had to invent ourselves. We didn't use precedent, we created precedent. We realized every single case for the first years would be a precedent. For capital punishment, we encountered proportionality. I'm fighting a totally losing battle in the United States to get a hearing for proportionality. But I would say in 80% of the top jurisdictions in the world, it's the centerpiece of our legal reasoning. It's balancing out the public interest with the rights of people, communities, in a proportionate way. That means it's contextual and it's balanced, and you give your reasons rather than through classifications. Anyway, I'm giving you another example of the kind of issues. So we found when we started, the Canadian Supreme Court provided us with the most useful precedent, not to follow their precedent, but to follow their reasoning, to see how they grasped issues, to see what ideas they had that we could use in South Africa. We found the German Federal Constitutional Court also very helpful. We found the US Supreme Court in a certain phase enormously helpful. And we found often dissenting opinions of US Supreme Court judges extremely helpful. But those,
I'm going to provide you with a lot to look at.
Yeah.
A lot to
No, well, it's that's one of the things that Sonia and I have in common, that we're never satisfied. Even when we agree for our own reasons. And sometimes our own reasons are something that you don't get in the formal statement of the law. Your own reasons, it's a deep thing, like inside, about dignity, about rights, what rights are really all about. And Sonia, one of the things I've been thrilled to hear on this visit, when I mentioned I'm going to speak, there's a great dissent, and we're going to print it out for you. Before I would read that Sonia Sotomayor dissented, now people are speaking about the dissent, and it tells me you're finding your language, you're finding your distinctive voice, and people like it, and people are inspired by it. Anyway, for the first years, we were all in that kind of a realm. Now, I'd say after about 10 years, we had foundations of our own jurisprudence. And I noticed today, we worked so hard. We went all over the world. India was a very important source for us. Australia a little bit, very technical, maybe too erudite. New Zealand a bit more helpful. The English House of Lords, when they adopted the Human Rights Act, suddenly started speaking our kind of a language. But for me, very important was the Warren Court era, because that's when I was a law student. For me, possibly the greatest legal decision ever given by a court in the world was the Brown decision, because it was more than just getting it right. It was getting it right at the right moment, in the right language, and it showing what the judicial function could be. That inspired me. It inspired my generation very much. After 10, 15 years, I read the decisions today. They're quoting Albie Sachs to agree or disagree with Albie Sachs. And so suddenly I'm converted into a precedent, not a precedent creator. I am a precedent. So I was an originalist, original intender, and now I am a precedent. And they're going beyond us. They're building up doctrine. It's so exciting to watch, because when things are going badly wrong in the country, in a way everybody knows what the president is doing is just manifestly wrong. And instead of Parliament being there to correct the president, the Parliament is ducking and diving, and now the Chief Justice, speaking for the whole court, says the president was told by the public protector to pay back the overspending on his private home for security. Swimming pool is not security. A chicken run is not security. A little auditorium is not security. He must pay back, and Parliament failed to ensure the president did that. There was like cheering in the streets in the country. Now, the doctrine they used for that was beyond what we had developed. And it's a very, in that sense, a very active court, a very activist court with a very activist constitution. I was asked by Justice Alito when I had, it was actually a rather feeble lunch, but a marvelous conversation in the Supreme Court. Justice Sachs, would you say yours is an activist court? And I said, yes, Justice Alito, but we have an activist constitution.
Well, we don't, as you know.
Right.
And our approach is decidedly different. But, you know, there's a temptation to make value judgments about that, and I think it's natural. But I also think, and I've been thinking more about this lately, which is that constitutions are reflections of their own culture. And so to the extent that yours is an activist, positive law constitution, you identified the fact that yours was a nation creating itself in a very different way than we were when we started. Freedom was defined in a particular way for us, first of all, because we had slavery, so we didn't have your vision of freedom. We had gender discrimination. We had, our definition was much more economic. Freedom of contract, which controlled our jurisprudence for nearly 200 years. Mm-hmm. And so with it comes a view of our world that's decidedly different than yours. And I don't know if that's good or bad. I do think that if we polled this audience, most people would choose yours. But I don't always despair about mine. How's that? I always have hope.
Right. So I'd like to dissent.
I just think we take longer.
Dissent from the dissenter.
All right.
I think your court is a very activist court. Mm. It strikes down. No, it actively strikes down gun control. It actively strikes down campaign finance control. It actively strikes down voting access control. To me, that's a very activist court. The difference is we acknowledge our activism, and you deny that that's activism. That's just applying the Constitution.
Well, I don't know if that's me personally.
Yes. Now, I think all courts are activist, and they have to be, because they're intervening in exercises of power, and it's how you rationalize it. And I was very struck, I'm not sure if you were already on the court when the Second Amendment case was being argued.
No, I wasn't, but I came on at the second round of the question.
Right. So I was invited by Ruth to sit in, and I was amused to see that all the judges who normally are very strong on the literal text and giving the widest discretion to people on the spot to make democratic decisions were suddenly discovering the text is fairly malleable and that the freedom to carry a gun is a fundamental right. And all the judges who were normally saying, don't be bound by the literal text, understand it in its context, its time, and so on. And there are certain fundamental rights that have to override the local democratic decisions, particularly for groups that are not well represented in the legislature. We're arguing the opposite. So to me, it just highlighted the fact that judges, particularly the top court in any country in the world, are required to intervene, to be activists, and the way they rationalize it, the language might be different. But I was inspired by judicial activism of judges like Brennan, Robert Jackson in his day, Thurgood Marshall, Harry Blackman, with whom I stayed for a while. But to me, the word activism, in South Africa, we struggled against apartheid. To be called an activist is a sign of praise.
For those who don't know you, Albie made mention that he was a victim of a bomb because of his political stance against segregation in South Africa. And he lost his arm, or part of his arm, and his eyesight in one eye and his hearing in one ear as a result of that. And as you can tell, it didn't stop him. I am realizing more and more as I'm serving on the court that respect for precedent is very, very much controlled by the sensibilities of the judge involved. That it is not a legal command. There is nothing in our constitutional order in America, or even in a statutory command, that requires us to follow precedent. It is one of those social expectations that we have in order to seem less arbitrary and capricious in our decision making. And I think that those are important values because the populace needs to sense that our decision making is not completely controlled by our personal preferences, but that we have constraints in how we express our views, or don't, as the case may be. But a constitution like yours gives you more freedom to find your own personal sense of justice. Am I wrong about that?
No, I think we take our precedent very seriously. We worked really, really hard. I've got one of my law clerks, Ting, in the audience here today. She knows we worked till after midnight. The law clerks had to check every single detail 3, 4, 5 times to make sure it was absolutely correct. We had workshops. I don't have another court in the world where we sit round the table and talk and talk and talk and come back. Or the same-sex marriages case, I think we had 5 workshops. It's not to refine the case, it's to get it right. So we took it very seriously. And in a sense, writing a dissent is respect for precedent. If you disagree, you don't just go along. You say why you disagree. We used to help each other when colleagues came to an opinion different to ours, I'd say, Zach, your argument would be stronger if you didn't put it this way, if you put it that way. Because we wanted the texture to be good. We didn't want to say, they'll see through you very quickly. They'll see that I'm smart and you're dumb.
Well, we do a little bit of that, not a
Yeah.
lot. We do a little bit of that
Okay.
because there is internal back and forth on drafts. So the dissent speaks, the majority will send a new draft poking holes at what the dissent is saying, and the dissent will adjust its presentation to address the more serious omissions or commissions of the work. So we do a little bit of that, but we don't do, I don't think anybody's told me how to improve my dissent who wasn't joining me.
Yeah, no, it's actually a comity thing. We'd actually say if you put in the following, that's a stronger argument against me. There was a kind of a pride in the institution. I'd love to give you and through you, the audience, an example of how precedent evolves. Most of your work is on the margins of precedent, and you push a bit this way and a bit that way.
Generally, there's splits in the lower courts because we're on the margins of the law and of precedent. So
and then
you're
you've got a precedent, and some are pushing in this, some in that direction. We have whole new areas that we have to establish a precedent. So we had a very extraordinary case. Nelson Mandela is the president. At the time, he was the president. And he signs into law a new Medicines Act, which controls the dispensing of dangerous drugs and medicines. And he signs it into law without realizing it abolished the old law. The old law established a schedule of prohibited drugs that people couldn't have.
Oh.
And it abolished that. So we left as a drug-free, completely country. And he runs to court. He said, I made a mistake. Please withdraw my signature. And the High Court say, well, he made a mistake. He said he made a mistake, and I'll listen to him. Comes to, we don't like that. Once you sign, is signature, is it a legislative act? Is it an executive act? Well, it's a bit of both. It doesn't matter how you classify it. But we can't have a law that has the effect of destroying law. So we thought about necessity, very dangerous doctrine. We don't like emergency, necessity. We came up with rationality as part of the rule of law. The rule of law requires that all law must serve some rational principle. And this served an irrational principle. Therefore, the law was irrational. Therefore, the old law continued until Parliament corrected. Now, we invented that notion of rationality. Think this would happen once in 50 years. It's become the foundation of the strongest representation of judicial authority in South Africa at a time when people are feeling the Constitution is being disrespected by high incumbents in office. So if the President appoints somebody to be National Director of Public Prosecutions who's been held in a commission of inquiry to be somebody who doesn't tell the truth, that is irrational in terms of the Constitution, and it's an appointment that cannot stand in law. And they've really gone with that. And it's made me think of why does precedent emerge so powerfully and strongly in certain moments? Why did Brown come about when it did? It really overturned that previous law. It wasn't, you could find a little bit of precedent here, because the needs of society to United States in the world and in the United States to combat that overt racial discrimination was just so powerful. I call it the theory of not why or how, but the theory of when. And we have a theory of when we develop this doctrine of rationality to affirm the Constitution, when incumbents are repudiating the Constitution and in the way the public can respond to. Now rationality, something goes well beyond any precedent that Albie Sachs or Cato Regan or Ismail Muhammad was thinking about at the time.
Well, it's far beyond anything we would do here.
Sure.
We permit felons who have committed public transgressions to serve if they've been elected. So it's very far afield from the American system. For those of you unfamiliar with South African history, I was there last summer, and there were allegations of corruption by the then president. And there was some parliamentary maneuvering going on whether his party would refuse to give him a vote of confidence or to call his vote of confidence into question. They ducked that issue, but the charges of corruption did not stop. And what Albie was describing earlier with respect to the swimming pool and the other items were part of the things that I think ultimately led to his removal from office, if I'm not mistaken.
He stepped down.
He stepped down.
And what's so important was it was the Constitution lives, because tanks didn't go into the streets, 1 million people didn't go into the squares. He knew that if he didn't step down the next day in Parliament, you have a parliamentary chosen president, like the Prime Minister in England. It's not directly elected. He knew he would lose. He'd prepared a speech. It was self-serving all the way through until right at the end. He said, and accordingly, but it was almost disaccordingly, I resign as from this moment. And clearly somebody had come in and said, Comrade President, the vote's going to be against you tomorrow. Tomorrow, the charges will be presented to him in court.
I will tell you a story that greatly moved me when I was in South Africa. I went to Robben's Island, which was the penitentiary, essentially, that held all of the freedom fighters during the resistance to segregation in South Africa. Mandela and all of the South African leaders passed through that island at some point or another. The island tours are done by prisoners, former prisoners, and we went on a tour with one of those former prisoners. And a young man, I don't know where he was from, but he was clearly African, of African descent, asked a question of the tour leader, and it was whether he regretted the time he spent in prison, given the corruption of the then president, and did it render naught his imprisonment. And it was like watching a man feel his entire being almost lifted, the tour guide, lifted off the ground 2 feet. And he said, how can you ever regret fighting for freedom? And then he said, what we have to do now is do what we were charged in doing then, which is to ensure that our government stays pure. And if we're unhappy about corruption, we have to change it. It was just such an extraordinary statement. And I left feeling the people's sense of commitment to their own existence, to their own government, to their own sense of what was right under their laws. It is a tribute to South Africa that kind of sentiment is still alive and very present.
And at the moment, it's in the ascendancy. It's a very fine moment. When Cyril Ramaphosa, who took over from Jacob Zuma as president, made the SONA State of the Nation address the next day, he started off by introducing people who are here on this occasion, and he mentioned important figures in the parliamentary setup, and then he said the Chief Justice of South Africa. There was a huge cheer, the biggest cheer of the day, more than any cheering he got as president for the Chief Justice. And that's because the court has played such a central role. I just felt so proud that the precedents that we were established are actually feeding into public life, but also the erudition, the thoughtfulness, the emotion, if you like. I think there's a thing I call judicial emotion. It's not just anger or rage or sorrow or laughter. It's a kind of a feeling about what's right and fair and just. All of that came through, and to hear a Chief Justice get that applause from the very Parliament that he had castigated was quite beautiful.
So, what does America do? How do we train our academy, our law professors, our students, our lawyers to have the courage to think more broadly?
I think...
And you notice I said the justices, if you have suggestions for me. I consider any suggestion ever given to me.
Yeah.
But I do think that we would have to start with a social change that would require a broader involvement.
I come to learn, to hear, to smile, to laugh. I always laugh in America because and in fact, I mentioned last night when I was in conversation with Darren Walker Ford at CUNY that one of the signs of strong democratic health in South Africa, one is strong investigative journalists, and we've got them plenty. The other is stand-up comedians. And we've got them plenty, and you've got them here, and you've even got at least one of ours
Yes.
here in the States. And I say it jokingly, but in fact, it's not a joke, it's true. You need an open society that can laugh at itself, that can be angry. It's so inspiring when we in Cape Town read that high school children are marching to say that we want gun-free schools. It's thrilling to us, and they're doing it in a kind of a noble, organized way because that's what they feel. That's what they feel. I'm hearing, I spoke at Ann Arbor last week, the professors there said they're getting the best students they've ever had. The students, so I don't think there's anything genetic to explain it. I think it's what you're calling the cultural changes, the people feeling that to some extent the Constitution is out there on the line. It's not something we just take for granted. It's not a given. It's not automatic. It's got to be given meaning and reverberation and significance in our lives. So I feel in that sense, although many of my friends in the US are in a state of such almost despair, almost equal to the way they felt during the Iraq War, which happily came to an end and ultimately was repudiated, I find enormous vitality here, a great energy here, and if there's good that comes out of bad, it's people are rising to the challenge, are speaking out. And I'm going to flatter you now, not just to get your approval because we're on the bench together now, but it's really lovely, Sonia, to see the way not only young people, but older professors respond to the sparkle that emanates from you and your pen on the bench. And even if the vote goes against you, you are keeping alive, if you like, what I believe will be the stronger precedent, that precedent of humanity, of caring, of respect for human dignity, that I feel will outlast the more technical, formulaic kind of approaches that are resistant to what millions and millions of human beings really want.
One of my continuing efforts in recent years on the court has been to reintroduce civic education into our middle school teaching. Mm-hmm. Believe it or not, in the 1980s, it got withdrawn from school teaching. One might question whether the division in the United States is a product of that decision. Because once you stop teaching people the meaning of their own existence, their own community, I think that's when you perhaps lose the value of understanding and of speaking and trying to engage. But for me, that is the missing key in America right now, is civic education. And every forum I have, I am promoting this message because you're right, those high school students showed us that that spark can set such an important example. Putting aside that all the sociological data tells us that students who are taught civic education in middle school become student leaders in high school and college and do better in their studies. Mm-hmm. There is something about teaching people to care about community that inspires them to do more. And so I'm a very firm believer in that. Your whole life was a tribute to that, the life of all of the justices on your court. It is interesting that that has become less of a criteria in our country. If you think of the members of the court, our founding fathers, whether it was John Jay or James Madison or some of the other leaders of our earlier court, they were all very actively involved in the revolution and in creating our Constitution. They were what Justice Scalia used to call citizen lawyers. And that part of being a judge has been minimized in more recent times. That idea that as a lawyer, part of your professional obligation is to engage in society and in bettering it and maintaining its values. And so I think that too has been a corrupting influence in how our interpretation of law has changed.
Well, you did us a big favor when you came to the University of Cape Town to be in conversation with me. We spoke for a little while, and the next thing I know, Sonia's gone. She's there up amongst the students. She's put her arm around them. She's chatting to them. And I just loved it, because we still have a certain tradition of that judge as an austere, remote person. And so here we had this great American judge from the US Supreme Court. I think they think all the US Supreme Court judges do that all the time.
Well, I'm not doing it today because this is a parlor room conversation.
Yeah.
And so, but I do usually do it. I mean, part of, I think, what I really do love about the South African judges, the few that I've met, is that they are all very involved in community activities, even as justices, which that is not necessarily true for myself or my colleagues.
Yeah. I mean, we're very strict on not being too close to political groups.
Yes.
To commercial groups. Very, very strict on that. We were dying to get support for our Constitutional Court artworks collection, and all the insurance companies were dying to help us, and we said, no, thank you. You might be litigants before us. So we're very strict. Maybe we're more rigorous than I've noticed some judges here seem to have social and other forms of contact, sometimes duck shooting or stuff like that we read about, which we wouldn't do. But we are aware of the inequalities, the injustices in our society. It's just so stark. And maybe it's a big difference. Our point of departure is not that we're living in a good country, don't let government mess it up. Our point of departure is we're living in a bad country. It's grossly unequal, it's grossly unfair. The stigmata of centuries of racism are profound. They're in the body of our people. You notice it all the time. So the Constitution then speaks about the injustice of the past. And to do your job as a judge, you're combating the injustice of the past that is still strong in the present. So in that sense, some people, it's in their faith communities they do it, others in housing groups, in health groups, education groups. In society generally, we're very participatory. We had one difficult moment for me on Constitution Hill, where our court is. The organizers, the controllers of the Hill, decided to have Afro-funk on Constitution Hill. Do you know Afro-funk?
No.
Anybody here? Maybe it's not all that strong, right? A couple of people.
The couple are shaking their
from
heads.
Chicago.
They're younger than we are.
Yeah. And it's a kind of, it deals with intersectionality, race, gender, bisexuality. It's very expressive. It's not condemnatory. It's fun. It's dancing. It's showing off. And we had thousands of people, many had come from all over the world, on Constitution Hill. And it turned out to be a liberating experience for our Hill, to put us in touch with another generation that are expressing themselves, enjoying the right to express themselves, the right to be different, on sacred ground. That was a little bit hard for me at first, but when I saw pictures afterwards, I just felt very, very liberating.
For any of you who have the opportunity, and if you don't create it, go visit South Africa, and the one part of South Africa you cannot miss is Constitution Hill. It is an entire area devoted not just to the Constitutional Court, whose architecture, decoration, and structure is a tribute to this new Constitution and to its vision. So instead of being high up, the court is low down. And through the sides of the window, there's a window opening to the street level where you see the feet of people walking. So instead of a closed room, you have what appears to be an open room, and is an open room despite being lower down. But most importantly, and I thought of it as I was in the room, the judges are reminding who they're serving. Because to watch people's feet, and it is a reminder of that missing element in the courtroom, the people. It was really quite a moving experience to be there. But surrounding the Constitution building, court, is the prisons that housed, again, many of the resistance leaders, but also some of the traditional criminals of South Africa. And they've turned them into museums. And walking through those places, seeing signs up that say, whites get this amount of provisions, mixed race people get that amount, and the blacks get this tiny, lesser amount, was a living reminder of what their world was like for how long. But I would encourage everyone who's interested in the law and in justice and in how to motivate yourself to be involved, I would go there.
Can I ask you a question, Sonia? I think the first time I met you, you were on the court. You hadn't been on long. I was leaving.
I was a baby justice.
You were just coming on, yeah. And I was waiting for transport, and you were waiting for transport, and you were a little bit agitated. It was going, I think, to the Kennedy Center, and Ruth and Nino Scalia had just left for the opera, and you were saying you were waiting to go to gospel, and you said, I don't know if I really belong here.
I don't know if I really belong there.
But
I like to ask.
No, but what I've noticed then was you felt uncomfortable then in that atmosphere where the assumptions were, if you're on the court, you go to opera, and you don't go to gospel, and you shouldn't be seen at gospel. Now I get the sense that you've brought gospel to the court.
Literally.
Yes?
About a year after, I was asked to host a gospel luncheon at the court, and I said yes. It was one of the first musical events I hosted at the court. Mm-hmm. I brought a group of students from the Bronx involved in a choir that sings blues and jazz and other types of music, very different from the court's traditions. And they actually sang during a historical society dinner. So you're right. It was awkward adjusting. And it's not always comfortable. But I have accepted that I am there. And I am one of 9 voices, and I should express, as they do, what I think is right. And to that extent, it's become a little easier. I don't know that I feel even today fully integrated, but my colleagues are, as you know, very pleasant, always well-mannered. And even when they think I'm doing strange things, they may raise an eyebrow, but they don't say much. You had that question from my colleague, Sam Alito. It was probably sent in a very gentle manner. Are you an activist court?
Yes.
But I have the answer, which is if you disagree with precedent, I doubt you would follow it. Or maybe I'm wrong about that. But at what point do you think that the court should eschew precedent? When do you think, we have a whole doctrine on stare decisis, which is what we call following precedent.
Yes, yes.
And the doctrine has about 5 factors. It asks you how long the doctrine's been around, essentially. Have other areas of law moved away from the foundations of that precedent? What's the reliance interest of the society in the precedents? What is the sense of balance between keeping it and letting it go? All of those things are part of our equation, and it's very mechanical in some ways. But in the end, one could make an argument of overturning any precedent once a majority disagrees with its foundations. But I don't know that you get a stable society if you do that. Have you given some thought yourself as to what would motivate you to say at one point, this far is enough, now we must change course?
You know what I found so fascinating looking at the American court experience? When I was younger, as a lawyer, we felt precedent was stifling. And the progressive, forward-looking people would look for reasons for overturning long-held common law principles from a very patriarchal society, principles from a very racist society, property-owning society. So we favored overturning precedent. I look at your court now and I find the precedents that are being overturned are the precedents from the progressive era. So these were precedents that to some extent were opening up the scope and the vision of the courts are now being overturned in relation to voting and campaign finance and so on. So I don't find the answer in the technical area. It's in the, if you like, the extrajudicial elements. So then I get disturbed when the very kinds of decisions and judicial vision that inspired me when I was a young lawyer are now being overturned. That distresses me, but it confuses me because my nature is a little bit turbulent. My nature is in favor of not being bound by the past, but moving forward.
Oh yes, you like creating chaos around you.
Yeah, sure.
Yes, you do.
And I've got enough colleagues that's one advantage of being in a multi-member court. You can really fly, you can soar, because you've got enough ballast in your colleagues, to keep you connected to the earth. Whereas if you're a single judge, it can be calamitous.
Oh, it can be very difficult, I can assure you. All right, so what do you like about the American system? Anything?
I like the fact that a judge can ask me that question. I like you write the best, this is a purely technical thing now. When we were considering how should we call them judgments, your opinions, be, what format should they adopt? I was horrified by the South African tradition. It would start off, the applicant in this case is a 53-year-old businessman, the defendant, this happened, that happened, the other. It's so boring. And you're not getting to the issue at all, and you have to get to page 3 or 4 before you even know what the case is about. So in our court, I introduced this case is about, or the fundamental issue in this case bears on something. That required a revolution in our judicial writing. And I looked at British House of Lords, very beautiful prose, lovely writing. Australian, super technical, every sentence has an explanation and a citation. New Zealand, Indian, very passionate, open. And I found in terms of the actual package, you guys have the best package. You set out what the case is about. You don't go into realms and realms of fact unless they're necessary. And
They're telling us we're going to end soon.
Yeah,
That's what that's about.
yeah.
I wasn't looking that way, so they
And
couldn't
I'm in the
win.
middle of giving you some praise.
Yes, I know. I know.
No, so you take it for granted that's the way opinions are written. So that's something I do admire, that you deal with the legal issues. It's not realms of facts. You get to it quite quickly, and anybody reading it can pick up not all that easily, always, but where the judges disagreed. And that is admirable. And we haven't reached that yet in our decisions.
Well, you know, Steve Breyer, our mutual friend, has written a book in which he explains, and I think rightly, that the amount of respect that a court will receive is proportionately related to how persuasively it can explain its reasons. That if people can read what you say and understand what decision you reached and the why of it, that it's more likely that they will respect that decision. It is those decisions, I think, that are obtuse or otherwise indirect that are likely to lead to confusion and less willingness to follow. So to that extent, despite the colloquial nature of some of my colleagues' presentations, there is some value to simplifying presentations for the people who are reading them.
Yes, and also you guys have the best punchlines. I've just noticed that sometimes you can capture so much in a sharp little pointed phrase, and it might be against what I believe is the best answer, but I do it by the skill.
Oh, Nino Scalia was
Right.
so skilled at it. Really, his are memorable lines that he's led to some of his thinking.
Yes,
So-
and I think that is a really worthy skill, because it's using language in a way to convey a lot of meaning that's very accessible to people. And I'm only, it was Booth of the Salvation Army said, why should the devil have all the best tunes? So why should Nino have all the best little snappy statements? But the fact that he did, and of course you couldn't become a Nino because you don't see the world in that way. But I get a sense that there's certain aphorisms that people will say, as Sonia Sotomayor said. I just sense that you're reaching that stage of sufficient confidence in your penning and writing, and also your acceptance, because the academy can be very harsh and very snotty and very sneering.
I see a lot of the professors shaking their heads, yes.
No, and it's been also admirable for me to see that you are a draw card. At NYU is one of the top place for brains, and
Don't give them more of a swollen head.
I'm giving you the swollen head.
Thank you. Well,
No,
I think
and I think that's, for me, it's a sign of great health in legal thinking. That you can be who you are. You can be a Latina woman of working class background, and you don't achieve acknowledgement and acceptance because you prove that you can be as waspy as anybody else. You come in as you are, and you contribute something very, very strong. And I think it's also indicative of an eagerness for that. A receptivity in all the different areas of the academy and in public life generally.
now, Albie, I know we have to stop because the students have a class in less than 10 minutes. But I think this is a conversation we're going to continue for a long time. I'm still growing, and you never stop growing, even though you're not serving on the court. I know you're still writing and thinking about these issues, and every time you write something, I read it with great pleasure and with much new thinking that you provoke. So thank you for being a part of our talk today. Oh.